All right, good morning. I'm Andy Gavel, and I'm delighted to be here with you. I want to thank Harry and NYU and Hausfeld and Epic. What a wonderful role they've all played. And as you all know, when you plan these programs, it takes quite a bit of time and effort, and it's just very exciting for us to see it all come together today. So I'm really excited about that. I'm going to do very brief introduction and bios. You have the full bios in the program. To my right, Rebecca Hall-Allensworth is professor at Vanderbilt Law School. Her antitrust scholarship has been cited by the Supreme Court, and she regularly comments in the press about antitrust reform movement underway at the agencies, if it's still reforming at the agencies. And she clerked for Judge Richard Posner before becoming a professor. John Baker, to my left, is Professor of Law Emeritus. What does that mean, John? Does that mean you're old too?
It's like Chairman Emeritus.
At American University, Washington College of Law, and he's a fellow and senior academic advisor at the Thurman Arnold Project at Yale. He has served, among other things, as the chief economist of the FCC and as the director of the Bureau of Economics at the FTC. Daniel Francis, where's Daniel? To my right, there we go. Daniel is one of our co-hosts. He teaches antitrust at NYU and was previously deputy director of the Bureau of Competition at the FTC. And John Newman is professor at the University of Miami School of Law and former deputy director of the FTC Bureau of Competition, where he helped oversee the agency's monopolization cases against Meta and Amazon. We're going to start with about 5 or 7 minutes each of sort of opening remarks. We're going to start with Rebecca. We'll go back and forth, and then we'll open it up for discussion and hopefully for questions from the audience as well. So Rebecca, please get us started.
Okay, well, first I want to thank everyone who invited me to this. It's a real thrill to be here. I also want to say a special thank you to Eleanor Fox. When I started in the academy, Eleanor was the lady on the panel, and now I get to be the lady on the panel, and that
We will call you Eleanor.
that feels pretty good. Okay, I think monopolization law has for a long time struggled with the question of how much must we give monopolists the stuff that they want, the profits, in order to induce their innovation to create the monopoly in the first place. Okay, so this would suggest that there's two different ways of thinking about innovation. So one would be that there is a prize out there. There is a monopoly prize for which companies will strive and they will innovate. And once they have it, we ought not to take it away or not take it away fully, lest they don't strive to get it in the first place. This is something you would see in the Alcoa opinion, and you see it at its most highest form in Trinco. But there's another kind of innovation, another thing that drives innovation, if you will, and that's ease of entry. So the ability to bring something to market, the ability to quickly reach a bunch of consumers is another thing that incentivizes and drives entry. To see how they are traded off in the typical platform antitrust case, of which Microsoft is kind of the, the granddaddy, maybe. Think about a platform's incentives to deal with properties sitting on its platform. If it wants to maximize the returns from that monopoly platform, it can disadvantage those competitors in ways that inure to its monopoly profits, create this potentially large and long-lasting monopoly prize, and in a dynamic sense, incentivize the creation of that platform. But it also, by doing so, disadvantages those sitting on the platform and suppresses competition among them and also therefore suppresses innovation. So this tension involves trade-offs of two different kinds of innovation, different sources of innovation, except when they are sometimes the same thing, which I'll get to in just a second. Another way of saying this is that for a long time, antitrust has been really worried about free riding. Free riding is a flag you can raise in a monopolization case to find no liability. But what I want to say is free riding actually can inure, in a long-term sense, to consumer welfare. That's something that, at least maybe since Trinco, we've kind of lost sight of. So This, as I said, these two different visions of what could be driving innovation, and the answer, of course, is that both of them are, right? Ease of entry and the appropriability defense, as my panel mate, John Baker, has called it. Both of them drive innovation, and they are often in tension with each other. The case that really does the most to apotheoze, to raise up and really prioritize the prize theory of innovation is Trinko, which says that we can't go after this monopolist, we can't force them to share because doing so would erode the incentives to create the platform in the first place. This is stated in extremely strong and general terms. It's been cited a lot, and I'm not here to talk about Trinko, I'm here to talk about Microsoft, but there's plenty of criticisms you could make about that case. But could it have been a different way? Could we have gone a different way? Oh, and by the way, in that case, it was used to incentivize the creation of a platform that had existed for almost a century. So whatever monopoly prize was going on there had been the source of revenue for this company. The innovation to create the dominant platform had been a century old. Okay, so what does Microsoft have to do with all of this? Maybe Microsoft is a story of what could have been, a different path that the court could have chosen, or the courts, I guess, could have chosen before it kind of committed itself, and maybe not in a totally permanent way, which I'll talk about in a second, to the Trinko dominance of the prize theory of innovation, rejecting that free riding, free entry model of innovation. How does Microsoft raise the prize theory? Well, essentially, Microsoft's defense was this kind of, it's mine, I can do what I want with it defense, this property defense. This sounds in the idea of the prize theory. We got this because we built something great, and you can't take it away from us. If you think about the principles behind, there's Lockean property, but there's also the idea that property rights exist in order for people to strive to get them and then to use them productively. So this idea that it was their intellectual property in particular here that couldn't countenance free riding. And by the way, the lower court opinion in Microsoft talks about free riding extensively, and that's not really discussed very much in the appellate opinion. So they make this argument about their intellectual property. This is our prize. They also make a kind of implicit threat. And this threat is a little bit more present in the tech cases of today. It goes kind of like this. Nice platform you got there. It'd be a shame if something happened to it, right? It's like this thing that we built that you all use and has driven consumer welfare, a huge amount of almost immeasurable consumer welfare would not be possible if you entertain a monopolization suit against us. Microsoft kind of made that argument by virtue of producing pretty weak pro-competitive justifications. Okay, maybe the best they had was this free riding pro-competitive justification. And then the stakes were very high at the time. That threat felt very meaningful because we were at the brink of a new economy. We were all thinking, as David Boies pointed out, everyone was thinking maybe antitrust shouldn't even apply to high-tech markets. We don't know what's going to happen. It felt very high stakes. So what did the court below do in Microsoft? It did two things, and I don't want to overstate the embrace, or that's not quite the right word. I don't want to overstate the pushback that the lower court opinion did to the prize theory, but it did some. First, it rejected all the free riding pro-competitive arguments, and then it imposed a remedy that would have allowed free riding. It would have opened up the platform to more companies sitting on it. Now, the appellate decision undoes sort of both of these. It's familiar how the appellate decision undoes the remedy. Less familiar is the way in which they undo the rejection of the free riding arguments, because the appellate opinion is written in the following way. It says, not that Microsoft makes bad pro-competitive justifications, that we're going to reject their free riding pro-competitive justifications, but it says Microsoft made no pro-competitive justifications. That makes it sound like anything will do. Just get up there and say something. Say something about how this design worked better. Say something about how this allowed for more, and now these should sound familiar, privacy or integration or interconnectivity, right? Say something, say anything. And then you have a line of cases that runs basically through Allied Orthopedic that says, if you say anything about your product design, you're good. All right, so that is the way in which the appellate decision kind of undid the promise that Microsoft may have had to kind of soften our attachment to this prize theory. So then you have Trinco, right, and we're just really loving the prize theory. And if you think about that idea of property, and it's just inviolable, and this is actually something that David pointed out earlier, that idea that, there's something about the natural law of owning something. And then you think about Scalia's use of reaching into the bowels, like this disgusting bodily property idea of what it would mean to force sharing, to force...
Judicial proctology.
He really has a way with words, but like, that one really takes the cake for me. Okay, so then we have Trinco. Trinco's terrible. We'll save that argument for another time. But I wonder if Microsoft could have done more to not tee up what happened in Trinco. So what does this mean for today? Are Microsoft's promises of maybe enforcing free riding, right, embracing free riding, thinking differently about monopoly prizes, do they have any relevance today? And I would argue that they do. So, okay, Qualcomm is the latest case that's in the monopoly prize theory. Qualcomm should be able to do what it does because it maximizes its profits. If it maximizes its profits, it's good because that incentivizes innovation. That would be a counterexample. But I would put the Judge Mehta's decision in the Google search case on the other side of things. Maybe invoking the promise that Microsoft once held that got lost in the last couple of decades. In particular, the rejection of what is amounted to Google's kind of property arguments, right? This is our product, we built it, it's great, it got big because it's great, and we ought to be able to distribute it and share revenues in the way that we see fit. Also, TBD, will the remedy maybe be some kind of forced sharing, be some kind of free riding? Maybe we all ought not to be so afraid of free riding, and maybe Mehta will agree with me. I hope so. Who knows? Okay, thanks.
Terrific.
All right, John.
All right. Thank you, Andy and Harry and the conference sponsors for inviting me. And nice to see you all. I actually talked about the Microsoft decision at a conference at NYU almost exactly 15 years ago. And I talked about some of the same things I'm going to talk about today. So, Daniel and Harry and Eleanor and Dan and Scott, and you're on notice. I expect to be invited again to NYU 15 years from now to pop up like a cicada and talk about Microsoft one more time. I'm going to briefly say point out some of the affirmative contributions Microsoft made to antitrust law, but that's not most of what I want to talk about. So I'll just do that quickly. It refined the analysis of bad act, the conduct plus willful acquisition and maintenance of framework for assessing monopoly power under Section 2 by adopting a burden-shifting approach that recalls Section 1. And it clarified that the exclusion of nascent rivals satisfies the requirement that a defendant's conduct have a causal connection to the alleged exercise or maintenance of market power. It established that government plaintiffs must show that the monopolist's conduct harmed competition, not just a competitor as a plaintiff, but the government plaintiff too. It reaffirmed that the exercise of intellectual property does not insulate a firm from antitrust liability. It established that whether conduct constitutes competition on the merits is a legal conclusion derived through the application of its burden-shifting approach for evaluating the conduct element. That's how I read the implication of the way that Microsoft equates competition on the merits to a non-pretextual business justification the defendant might proffer after plaintiff satisfies its initial burden. But I want to talk about what I describe as negative contributions and just sketch very briefly a hypothetical counterfactual opinion that would find for Microsoft, either from a majority or a dissenting opinion of the DC Circuit, that would assert that antitrust law strongly presumes that competition and consumers benefit from unilateral conduct or vertical agreements by firms in rapidly changing high-tech markets. There were precedents that actually David Boies and Rebecca both alluded to that could be read to exempt application of antitrust rules to the development of new products, at the time. There was a policy concern to avoid chilling innovation. And if you had an opinion that was that kind of counterfactual opinion, maybe by the majority, maybe just by dissenters, but either way, it could have transformed antitrust in the courts. It could have been endorsed and amplified by the Supreme Court, which decided Trinco just 3 years later. So the Supreme Court could have suggested that a broad non-interventionist view of unilateral conduct, by dominant firms ought to be the way we think about the antitrust law, and it could question the legitimacy of the prohibition against monopolization. And it's possible to imagine the court instructing even that the monopolization claims often make no economic sense. And, and leading over time more and more claims making no economic sense along the lines of what Judge Bork sketched in his book and narrowing to a minimalist antitrust. So antitrust avoided an accelerated transition to a minimalist, non-interventionist approach and the adoption of what today might be called the dynamic competition arguments for carving out exceptions to antitrust liability for firm conduct involving new product development or firm conduct in high-tech innovative industries. So why didn't we see that hypothetical counterfactual opinion? Well, the most likely proximate cause is that Judge Ginsburg, Douglas Ginsburg, who was the obvious intellectual leader to frame that kind of critique, actually was persuaded otherwise, by the district court opinion and the government arguments in support of it. He and Judge Stephen Williams, who was another antitrust conservative, both placed particular emphasis in their according to their oral histories on the absence of a non-pretextual justification for at least some of the challenged practices, and so it's hard, for a principal judge to write a counterfactual opinion saying monopolization claims and dynamic markets often make no economic sense when the defendants didn't proffer a plausible justification for the practices. Even though both of those judges had some sympathy for that holding, as their oral histories and Judge Ginsburg's later writings suggest. And there's a more fundamental or underlying cause that the political and economic environment in 2001 didn't have some of the features that prompted prior antitrust transitions in the 1940s and 1980s that would have justified changing course. There was a center-right coalition that had taken charge of economic regulatory policy in Congress and in the politics during the 1980s, and that was entrenched. There were a few other firms that would have seen themselves as potential antitrust targets like Microsoft, and small firms selling complements, like Novell, the one who had WordPerfect, saw themselves as potential victims. And the economic environment was not buffeted by forces comparable to industrialization before the 1940s or globalization before the 1980s. Even though there was a new information economy and the like, it wasn't of the same kind of, having the same kind of effect at that time. And economic thinking about antitrust was not changing in a way that would support less intervention. On the whole, the major recent developments at that time, like in the 1990s, the game theory revolution in microeconomics and the new empirical industrial organization supported greater antitrust intervention than the 1970s and 80s Chicago school thinking would have suggested, at least in targeted settings. So the dog that didn't bark in 2001 was avoiding a accelerated transition to a non-interventionist antitrust and not privileging conduct in innovative industries based on dynamic competition arguments. Those non-developments, I think, were at least as important as the antitrust law and probably more so than the affirmative contributions that I started with. Now, of course, in today's world, I think some of these concerns seem increasingly quaint because we've seen decades of growing market power, and we have a new administration that may have shifted economic regulatory policy generally. We don't actually know. It's kind of too early to know what they're doing with that. But there's a sense of one might get about zero-sum thinking replacing inclusive growth kind of ideas that were important in the past. And so far antitrust has not been the center of the storm, but it's only been a month. And that could easily happen, and when that does, it could, put pressure on the primacy of economics and undermine the way antitrust law fosters inclusive growth, but that is for the future.
Thank you, John. I think we've discovered at least part of the title of your article is going to be "The Dog That Didn't Bark."
That's what I was thinking, actually.
I like it, I like it. Daniel?
Thanks, Andy. I am going to just react in part, I think, to what John just articulated, because I want to take a slightly grumpy note about Microsoft. And I should start by saying there is, of course, including in the ways you mentioned, a ton to like and appreciate about the decision, including the bottom line result itself. But I think Microsoft has acquired the content of the decision, the substance of the decision, not the bottom line, but the reasoning and the account of monopolization doctrine it gives. I think we've been a little too wedded to that for the last 25 years. I think in some sense that's even become a bit of a millstone around Section 2's neck. And I think a little bit more critical distance from the substance of the Microsoft opinion would be great for monopolization litigation going forward. So let me just identify a couple of things that make me uneasy about monopolization litigation and analysis in the shadow of that decision. So the first is that the hardest question under Section 2, and I think one of the two great riddles of antitrust, alongside what is an agreement under Section 1, is what does the law of monopolization prohibit? What is the basic foundational rule? And on that central question, I think Microsoft really lets us down. So there's a famous account in the decision, just as John mentioned, of a three-step burden-shifting framework that is all about impact on consumers. It's maybe the most famous language under Section 2 today, outside of the famous bit from Grinnell. Conduct has an anti-competitive effect if it harms the competitive process and thereby harms consumers. In contrast, here comes the wagging finger, harm to one or more competitors will not suffice. And then again, exclusionary acts reduce social welfare, competitive acts increase it. Okay, sounds sensible. And we might start to think, well, that can't completely be right. There are a lot of things monopolists might do that might harm social welfare, but they're obviously not grounds for Section 2 liability. Price increases, bad product, exit from a market, many forms of refusal to deal, above cost predation. So we might be uneasy about that account, but okay, we read on. And it turns out, despite the depth and length and granularity of that opinion, that is the last we will see of a consumer again in the Section 2 analysis in Microsoft, and the last we will hear about weighing and assessing welfare effects on consumers themselves. And instead, under the banner of competition on the merits and all its little wizards and minions, in and out of the analysis come all these different values and considerations that are clearly different in kind from just whether or not the practice has benefited or harmed consumers on net. So, some examples. The OEM license restrictions. These are the rules that say OEMs can't add shell desktops or remove things from the desktop on a PC. Well, the court says that is capable or has generated an anti-competitive effect. Why? Because it has reduced rival browser share. Pure explicit harm to rivals. We might actually drop a footnote and remember that because this is a story about monopolizing the operating system market, the targets of the practice here, Netscape and Sun, weren't even rivals. They were complements to potential future rivals on what I think is the most natural reading. But the anti-competitive effect comes from pure harm to rivals. But acceptable pro-competitive justifications, the court tells us, includes protecting Microsoft against the need to make a drastic alteration of copyrighted work. I can imagine a ton of reasons to take that seriously as a pro-competitive justification. Doesn't have anything to do with weighing impact on consumers at an act level. Technical integration of Internet Explorer and Windows, one of the most famous components of the conduct. Well, that was an anti-competitive effect, the court tells us. Why? Because it limits rival browser share by means other than competition on the merits. Well, but we were just told that this is all about weighing effect on consumers. Where are the consumers? Where's the discussion of the inferential chain? Court tells us, but there's a pro-competitive justification we have to consider. And that's, well, some of that stuff was technically or commercially necessary to achieve Microsoft's preferred version of product design. Seamless transition between functions within a single window. Again, ton of reasons we might want to take that seriously. Clearly is not about weighing impacts on consumers of the individual practice. So the whole ballgame in Microsoft, the more closely we read that reasoning, seems to be a core of harm to rivals as such, combined with a pretty inconsistent rotating cast of other ideas. There are a ton of ways we might defend that, but whatever's going on is clearly more intricate than that consumer welfare weighing effect test that the court presents at the beginning of the analysis. And if the idea is that, well, look, some of these practices would provide a great basis for us to infer harm to consumers or benefit to consumers, well, that's fine. But then what I think we can and should ask of the opinion is you've got to tell us when we can make that inference from bare harm to competitors, and when we should just say, in contrast, harm to one or more competitors does not suffice. So that, I think, is the core source of my unease about Microsoft, but I want to point out a couple others that I think courts who take the language and substance of that opinion as something like a Bible for litigating a modern monopolization case try to take seriously and find that it can't quite bear the weight. So one is that when talking about what constitutes an anti-competitive effect, Microsoft, the analysis within the four corners of Microsoft tells us, what we're looking for is an anti-competitive effect in the form of harm to consumers. But it's pretty clear that Section 2, in a way we alluded to a little bit earlier, cares about at least three different kinds of thing when measuring that function. So number one, for sure, whether what the monopolist has done is harmful to consumers. But number two, it also cares about the nature of what you're doing. We apply much more tolerant standards to some practices than we do to others. Unconditional pricing, refusal to deal, predatory pricing, than we do to exclusive dealing agreements or tying. The third thing we care about that isn't just harm to consumers, isn't just the nature of what you're doing, is whether or not the harm to consumers arises from an impact on rivals. You might think of this as the Rambus question. Has there been an actual or potential competitor who's been impaired by the conduct, and is that the source of the harm to competition? So because Microsoft unites all these together, and because today we've come to think of this as the source of so much of the substance of Section 2 doctrine, an irony of the effect of Microsoft's size in the rearview mirror is that it now gets used as a tool to limit and narrow some pretty good, pretty pro-plaintiff standards that existed before the opinion was decided. My favorite example is the famous causal test under Section 2 in Microsoft, where the court says it'd be crazy to make plaintiffs prove that monopoly power was but for caused by what the defendant had done. Instead, conduct that's reasonably capable of making a significant contribution should be enough. That language was in Arita and Hovenkamp in 1978. Courts of appeal were using it throughout the 80s. But because Microsoft is now seen as the source of so much monopolization doctrine, there's a strand of scholarship that's getting some attention now saying, that flexible causal standard in Microsoft was really a creature of Microsoft's own facts, and we should limit it and cabin it in ways that would have been terribly shocking to the federal judiciary in the late 80s. So I'll leave it there. I one of the costs today of life in the shadow of Microsoft is that when we get outside of the very familiar shoeboxes and micro rules of the most familiar kinds of monopolization cases, we look to Microsoft for guidance about general principles of Section 2 and we don't find them. What's the consequence? That exotic or complicated cases like Qualcomm, like some aspects of the Facebook litigation, like all the cases we're going to spend time discussing today, run into this great headwind of caution that we might think of as blowing from Trinco, and we don't have a doctrinal framework that's robust enough to resist it. And even when plaintiffs win, this lack of clarity about what Section 2 centrally requires means that the opinions we get are not as robust, not as reliable, not as likely to survive appellate reveal as we might wish. I have some fear in that direction about the Google opinion. But we'll leave it there. Thanks.
Awesome, thank you. Other John Newman, take it away.
Well, thank you so much, Andy. Thank you to the conference organizers. There's very little that could tempt me out of sunny South Florida, where I'm pretty sure it's 80 degrees today. But the chance to talk about the Microsoft opinion and its implications for the groundbreaking, I think, historic cases that have been filed in the last couple of years was enough to do it. So let me start with something probably very uncontroversial. Microsoft, I think, looms extremely large over all of today's big tech cases. And I was doing a little thinking about why that is. I think part of its staying power is surely just the narrative, the force of the narrative that surrounds that case. And we got a firsthand account of some of that this morning already, right? This is a sort of sprawling, go-for-broke case that kind of pits the awesome power of the state against the equally awesome power of a rising, ascendant Silicon Valley. It's a historic victory at the trial court, partially undone by, at least in the appellate court's view, the judge's desire for fame. This is like Shakespearean in scope and power. And I had always thought of it as kind of a Shakespearean tragedy, but David's anecdotes made me think maybe it is a bit of a comedy as well. So thank you for that. I think part of its power also comes from the DC Circuit opinion being kind of a mixed bag for plaintiffs and defendants. And whenever I read Microsoft, I'm reminded of what the Second Circuit in the Berkey photo case said about Alcoa, which was kind of the Microsoft of its day for a couple decades. That court said, "It makes the cryptic opinion a litigant's wishing well, into which it sometimes seems one may peer and find nearly anything he wishes." I think that's kind of right about Microsoft as well. There's some stuff to love. It's very, very thorough. Each instance of conduct, I think, is dealt with. Each argument that the government actually pressed on appeal is dealt with. Compare that to another, far more recent government antitrust case involving Microsoft, where the judge closed out an opinion with, quote, "Given the compressed time the court had to issue a written opinion in light of the impending termination date, there will likely be errors in the citation, and for the same reason, the opinion does not address every argument the FTC makes." That is a different version of judging than what we saw in the DC Circuit opinion. So, love it or hate it, the DC Circuit was extremely thorough and I think, actually did a good job of judging. Quite a contrast. So two things that gave it its power. I think part of its outsized shadow, the Microsoft case, also does come from its methodological approach. That gave rise to a lot of, I think, what Daniel was just talking about. The DC Circuit opinion is an archetypical example of what I call lawless antitrust. What do I mean by that? So when you're untethered from the law itself, we were warned about this in the 60s, you're going to start rambling through the wilds, right? And I think that is kind of what the Microsoft opinion does. It kind of rambles through the wilds. Sometimes it, yes, stumbles on a kind of beautiful clearing with a nice waterfall, but other times it kind of stumbles into a scary part of the forest and we need to back out. But it leaves in its wake all these false trails and detours and traps for the unwary that I think Daniel was warning about. So what are the symptoms of lawless antitrust? Well, what's your starting point when you're crafting a judicial opinion? Is it the statutory text, perhaps, which I thought we were supposed to start with, from what I remember from law school? Is it Supreme Court guidance, right? Is it the most recent Supreme Court case? Well, before the Microsoft opinion cites a single piece of binding authority, it cites the American Economics Review, the University of Chicago Law Review, the Journal of Law and Economics, Joseph Schumpeter's book on capitalism, socialism, and democracy. The University of Chicago Law Review again, the George Mason Law Review, a different article in the George Mason Law Review, and the University of Chicago Law Review yet again. That's maybe a little bit of a cheap shot, to be fair, but it is a symptom of a certain methodological approach to antitrust lawmaking. Okay, setting aside the symptoms, what does lawless antitrust look like in action? Well, I think part of what it looks like is the burden-shifting framework that the Microsoft court sets out, right? The court says, famously, plaintiffs must prove harm to competition and consumers. We finally get some legal citations, great, but they don't actually support that tacked on and consumers statement. The court then says the burden shifts to the defendant, and the framing here is blatantly defendant-friendly, right? Whereas plaintiffs apparently must demonstrate things, defendants, we're told, must merely assert things. Okay. The burden then apparently shifts back to the plaintiff to rebut the defendant's claim. That's new. It has a kind of almost risible citation. It's like a CF cite to an out-of-circuit case. Whoa, you're creating a third step to this framework? I want to see a little more than that. We then see the framing of the defendant's burden and then this third step, you know, these emerging in a way that I think is out of step with the actual Supreme Court guidance, most recently on point, the Kodak decision, right, which talks about defendants having to actually prove and substantiate their justifications. Beyond all that, I think there is a big missed opportunity. When you don't start with the text of the statute itself, you might miss something. If the court had started with the text of the Sherman Act, Section 2 itself, it would have seen that the text says it's illegal to monopolize, quote, any part of the U.S. economy. Okay, well, there's an opportunity for a judge, if they want to explain the law, to say, hey, here's what a pro-competitive justification must do. It must rebut the effects in that part of the economy, right? So there's an opportunity for the DC Circuit to say, hey, if you come at us in the future with out-of-market justifications, we're just going to reject them out of hand. We have to follow the text of the statute. DC Circuit didn't do that, of course, did do some okay pro-competitive justification analysis, but that was a real missed opportunity. And that missed opportunity in particular is one that I think is going to hang, already has hung, really heavily over a lot of the big tech cases. We already saw it pop up in the Google case. We're going to see it pop up in the Meta case, the FTC v. Meta case. I suspect we'll see it in the other cases as well. And of course, it popped up in Epic v. Apple. So there's missed opportunities when you don't do law. And of course, I'm not saying don't do economics as well. But we've got to, I think, get the antitrust law back in antitrust law. All that's to say, I don't want to close on a grumpy note. Microsoft could have been far worse. Maybe faint with damning praise, but it could have been a lot worse. I think that's exactly right. And I think it's an exciting time, right, to be talking about Microsoft because it sort of ironically had a monopoly on Section 2 case law for a while. It kind of sucked up all the oxygen in the room for a long time. But if there's nothing else we can agree on, surely we can agree it's great that we have some competition to Microsoft.
Cool. All right, well, let me start by asking any of the panelists if they have questions of the other panelists based on the comments. It's very interesting to me that we're seeing sort of two sides to the Microsoft case. Give with one hand, take away from the other with the other. Rebecca alluded to what happens after, Trinco especially, and I've certainly heard it argued that Trinco somehow undermined or changed Microsoft. I've seen that argument, Qualcomm is an example. And the Alston decision, which you wouldn't think has anything to do with Section 2, really digs into the Trinco narrative, which is a very non-interventionist narrative. So should we be grateful that Microsoft is there or fearful that if any of these current cases get to the Supreme Court, we're going to get the next line of cases from Brook Group to Trinco to Alston, and where will this court go with Section 2 law? Anybody want to comment?
I'll say something about your first question about a question for just for
Okay, go.
For Daniel, really. I kind of worried that my colleagues on the end of the panel took the wrong color pill this morning.
Did you take the blue pill or the red pill?
I took the grumpy pill.
The black pill, yeah.
Here think about a market, and you have a monopolist, and so it's got maybe small rivals and maybe some potential rivals, but there isn't much rivalry. And the monopolist excludes essentially all the forms of competition that you can imagine. Which in this case would really be the way in which as you said, the complements would facilitate operating system competition by potential rivals in the future. Isn't it obvious that there's harm to not just to competition to consumers, to the buyers, just from excluding all the rivals? What more do you want?
So on those facts, who would disagree, right? Like I couldn't be more with you in my heart. But let me, by way of answering, let me pick up on your wonderful idea of asking, wait a minute, isn't there in a parallel universe another version of Microsoft opinion that comes out where Microsoft wins and does terrible damage? Because I think that's so right. But wouldn't that opinion look like this? In order to have an anti-competitive effect, a practice must harm competition and thereby harm consumers. In contrast, harm to one or more competitors is not enough. DOJ has shown here partial impairment to 2 nascent possible future complements of non-existent possible future rivals. DOJ, even on the friendliest reading of their burden of proof, hasn't come within a country mile of proving that any actual consumers will be harmed by Microsoft's conduct. So sorry, DOJ, come back with a better, stronger case. Isn't that the version of the Microsoft opinion in a parallel universe? And worse than that, isn't that what a bunch of courts have done by picking up the Microsoft framework and applying it to the facts that they see in front of them?
So, can I? Well, first of all, that was not the counterfactual opinion I was sketching.
Yeah,
It's a
sure. No,
different-
I'm just
different
offering you
context,
an alternative.
Counterfactual. But here you have sure, it's only a nascent rival, and maybe there could be others, but here you've shown that the firm has the ability and incentive to do that, and it's excluding the ones that are in front of it. I still don't know what more you want in order to you've constructed a way of trying to limit what Microsoft's doing to some narrow irrelevancy that isn't what the case was about. The case was about keeping out nascent competition in a very important and major way, and it seems obvious that would result in the very kind of competitive harm that you were worried about, and the court at that time had to be implicitly worried about. That was how courts thought in 2001. So I don't really see this, Dan.
So I totally agree with you that on the facts of Microsoft itself, like Microsoft should have lost, and really hard, should have lost by a country mile. But I think the failure to give an explanation of why, to grapple explicitly with, wait a minute, how and in what ways does Section 2 treat different kinds of conduct differently? When do we do that weighing? To pick up on John's great point, can it really be true that once a plaintiff has shown actual harms, the defendant's burden is to identify a non-pretextual justification, at which point the burden goes back to the plaintiff to value that benefit, which is almost always going to turn on improvements in the defendant's own business, and then show that on net competition was harmed. So I couldn't agree with you more that on the facts in front of the DC Circuit, they got it right. And so much good has come from getting it right. But what I lament is the gap between getting it right as they did and getting it right in a way that gave us a Section 2 framework we could really trust and that would hold up in the kinds of cases we see with Qualcomm. It would
Okay.
hold up in the tech litigations we're seeing right now.
Can I jump in here and ask, and just push you a little bit more on this? Is that all right? Okay. So I I guess the way I read that first part, where it says, look, we don't care about competitors, we care about consumers, and then that just gets left behind, is at least implicitly, competition is good for consumers, okay? And if you destroy competition, if you destroy your competitors without also offering some sort of, benefit to your consumers, that's monopolization. That's the way I read it. And maybe what you want is for them to have said that more explicitly. But I also know from your other work that you do not want anybody to say anything about competition, actually. So help us understand how this opinion could have been better written in a way that would have made your life easier when you were in the enforcement world.
That's a great question. So one thing that I think is terribly harmful is the idea that you have an irrebuttable shield from the antitrust laws if you can persuade a fact finder that what you're doing is competition on the merits without us having in the fabric of Section 2 a sense of what that means. For some courts, it's conduct motivated by a legitimate purpose. For some courts, it's conduct that can be shown to be beneficial overall. For some courts, there are specific kinds of behavior, like above-cost unconditional pricing, that even when they harm consumers and competition, can never be the source of Section 2 liability. So the fact that within the four corners of Microsoft, Microsoft is allowed to say, avoiding drastic change to copyrighted work is a pro-competitive justification, without even trying to connect that to a consumer impact, I think that's a harmful thing. I don't think that's out of the family tree that leads us to Qualcomm. The fact that Microsoft can say, oh, it is and have accepted by the DC Circuit, it is a pro-competitive justification that we need to do X in order to have our favored product design, that is seamless transition between functions in a single window. That is in a straight line with the kind of deference to product design decisions that we were talking about earlier. So, I don't want to overstate the unease that I feel about the decision, but I think the fact that we're still, after 130 years, trying to figure out what the elements of a Section 2 case are, and when and how exclusion matters, the Rambus question, when and how the nature of what you're doing matters, what you might think of the Trinco question, Microsoft enjoys more consensus support, I think, than any other modern antitrust case. Wouldn't it have been great if it gave us an operationalizable version of monopolization doctrine at the same time?
That's a big ask, right? That's a lot. It is a lot to put on one appellate court decision. I guess if I could pose a question, there's a thought behind it, of course. More of a comment than a question, but there's a question too. The question is, what Microsoft did do, so I was setting aside what it didn't do for just a moment. What it did do was kind of concretize this formalized burden shifting structure, right? The question is, does doing that necessarily turn what, on my read, used to be a kind of a rebuttal? Like defendants could rebut the plaintiff's case, but we at least stayed focused on that, right? To kind of Daniel's last point, we aren't totally rambling out into like, is IP law good or bad, right? Does structuring the analysis in that way formally naturally turn and inevitably turn what should be a rebuttal into a defense? And isn't that kind of at the root of a lot of this?
I mean, I think that's right. I think that what the burden shifting framework has done has been to say, you have your anti-competitive exclusionary. I mean, I think that's the content of Section 2 is that you excluded. And then they say, oh, but, we're the best search engine, or walled garden, or it's just whatever is good about your product, because we have confused the idea of consumer welfare with some sort of direct, and I think Microsoft does contribute to this, some sort of direct, like looking at consumer welfare, like how happy are those consumers in there, which I think is more like a defense than a rebuttal, because it's sort of a non sequitur to the tale of exclusion. I think that's right.
Are there distinctions in what we're talking about between a monopoly maintenance case and a monopoly acquisition case? Does it make a difference in Microsoft that it was a maintenance case? And that affects how it looks at conduct and what the conduct is. It goes to your point about the narrative of we did something really good, which is why we got big, is a maintenance story. It's not necessarily an acquisition story, especially not if it's through, Ghana was looking over for David, unless it's through a series of acquisitions. That's sort of a classic acquisition story. most of these cases are maintenance stories. Facebook may be the exception. So is that part of the tension here? Is that Microsoft is trying to deal with a particular fact pattern that typically presents as we got big through competition on the merits in some way, and the issue is, did we then get bad?
So I cannot think of a single monopoly acquisition case. This is like a really dangerous thing to say in front of like 100 litigators, and you're going to come to me afterwards and be like, well, what about da 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 da? But like really, it's almost a null set. Like the big major cases that we talk about, I would say all of the 5 that were alluded to, including the Facebook case, because they're maintaining their dominance by buying up this nascent. And it's just kind of the nature of Section 2, because you have to show you are a monopolist. Usually, you know, that sort of goes along with the idea that you were maintaining it. So I'm not sure that that's the distinction, but I definitely do think that I do think it plays into the comments I was saying earlier, because so many of these monopolization maintenance cases have to do with a platform that are, you know, trying to prevent themselves from being toppled by dealing poorly with their platform dominant entities. But I also think that the framing of Microsoft in that way, how hard Microsoft worked as a litigation strategy, which I'm sure was the only way to really do it, at talking about horizontality. It's all about Microsoft, the platform, defending its own market power. It's not about, in fact, the whole attempted monopolization thing is just rejected. I think misses the kind of dynamics that I'm talking about, right? So by framing it purely in terms of what Microsoft was doing to protect its own operating browser, misses the things that it was doing in the platform-dependent market, and you know, and the kind of innovation that we might get from there.
I might throw in there too. I don't know if the maintenance versus acquisition distinction plays as large a role, in my mind at least, as maybe just how much time has passed since the crux of the conduct. So if you think about something like the FTC v. Meta case, one of the things that does make it hard is Instagram acquisition was, what, 12, 13 years ago at this point? And one of the things that makes Microsoft kind of jump off the page is, man, the conduct is like ongoing, right? It's very lively. The government's in court asking for a PI, I think, to try to block the release of Windows 98 at one point. So that, I think the passage of time can make things really hard. And in Google in particular, right, Google's been the biggest search engine in the world for like 25 years at this point. So whether it's an acquisition or maintenance claim, I think the passage of time is what kind of makes it hard for the judge to resist Google's urge to say, hey, we're just the best, right? Because they've just been the biggest for so long.
All right, are we supposed to open it up to questions? I thought we were supposed to do that. Yeah, all right. Steve, go ahead.
John, of course, is right, and Daniel, of course, is wrong. The reason why Daniel is wrong is because it's...
There's a microphone, there you go.
I'll repeat it.
Yeah.
Jonathan is right, and Daniel is wrong.
I like it so much better amplified, Steve.
Could you repeat it one more time, please, Steve?
With an
Daniel,
echo
Can you
effect this
amplify
time.
your point, please?
Daniel's error is that, in his counter opinion, is it's just a matter of the causation standard, which he applauded previously as coming from Arita and Hovenkamp. I mean, sure, they could have found the other way by putting on a high causation standard. That was the miss. But the basic idea that John made, that if you've got a monopolist and the monopolist is protected by entry barriers, and the monopolist and the entry barriers are getting reduced, and the monopolist prevents the entry barriers from being reduced, then it follows, like night follows day by a country mile, that there's going to be consumer harm from raising rivals' costs in that way. And so I think what you pulled out is not right in that regard.
So for sure, right, if you turn the causal sensitivity up high enough, any impairment of significant rivals would check the box. My point is this. If we have a test that requires for a plaintiff's prima facie case to prove harm to consumers and not just harm to competition, and then send that test out into the federal courts, the federal courts, so I'm thinking of courts applying that standard. I'm thinking of Amex, where in the face of a demonstrated after-the-fact price effect, the court says, no stage one showing, that's not an anti-competitive effect. I'm saying that in order to construct John's alternative universe, where the Microsoft opinion really didn't help and in fact hindered monopolization enforcement, you could do that with language identical to the language that they gave us. Because putting that language in the hands of the federal courts, rather than something that clearly allowed the standard to be satisfied on a lesser showing, significant exclusion that's reasonably capable of making a contribution to monopoly, that, to my mind, that's a really significant delta. But for sure, on the causal standard you suggest, that standard could do plenty of good work for plaintiffs.
Yeah, well, look, had Microsoft simply followed Kodak, which was very clear about harm to competitors leading and harm to competition, I think that's the standard you want.
Much closer to it.
There was another question right over there.
So actually, I have two questions. The first is this: can Microsoft be successfully distinguished on the ground that the trial proceeded expeditiously, and that as a result, when it came up to the appellate review, the DC Circuit said, on many issues, browser market, the justifications for its conduct, there was an absence of a record created by Microsoft that would justify the court accepting its view? That's point one. Point two is in the Section 2 analysis. The court in Microsoft was confronted with the question of applying the standard on a motion to dismiss. Should you do this holistic analysis and look at all of the activity together? And the court said, under the facts of this case, we shouldn't do it because it has not been demonstrated by the judge, looking at the totality of the evidence, that there was anything to that except a bunch of summaries and the fact that Microsoft invested in its browser, which the court found was totally possible. Go ahead to Judge Mehta's opinion on summary judgment in the Google case. And Judge Mehta there held that, no, you really have to look at each item of conduct separately. And that's what Microsoft held. And the motion to dismiss standard in cases like Continental Law has no application on the summary judgment motion. And there is at least some language in the most recent Mehta decision by the DC Circuit, which suggests that it might have that view of Microsoft as well. What do you all think of that?
Maybe a couple of thoughts. Maybe the first one, not directly responsive, but I was hoping somebody might ask something that would give me a chance to point it out. So there is this really striking passage at the beginning of the DC Circuit's opinion where they say, oh man, the computer industry, it just moves so quickly. Judges are going to get it wrong if they ever try to weigh in here. And then like a paragraph later sort of castigates the district judge for moving quickly. So I guess all that's to say, I'm sympathetic to district court judges. What are you supposed to do? Are you supposed to have a long, drawn-out, 4-year, 5-year litigation track with an 8-month trial and separate remedy phase? In which case, apparently, you're going to get it wrong because the industry is moving so quickly. Or are you supposed to move quickly and try to get something meaningful on the books? I just don't know that Microsoft leaves a good answer there, right, to your first question.
Do you think that defendants in subsequent cases have corrected the error that Microsoft allegedly committed and now have an expert to cover everything, regardless of whether it's permissible or not?
Yeah, well, whether it's defendants or plaintiffs, we've certainly seen some long, extended discovery, right, extended motions practice. So yeah, the litigation tracks are getting really long. Let me, though, pause.
I just-
My co-panelists.
I'm not sure I agree with the premise. I think the Microsoft case was processed incredibly quickly compared to the current crop of cases. Judge Jackson did a whole bunch of procedural things. He combined the preliminary injunction with a full trial. He did discovery quickly. When he got to the trial, he took all of the main testimony in writing. The direct testimony was done in writing. He really tried to move that case along compared to today. That case was it was filed in May 1998, and it was decided by the DC Circuit in May 2001. The current crop of cases have taken longer than that just to process in the district court. So I think there was something lost between then and now in terms of how to move cases along expeditiously. Microsoft was not slow.
I wonder if we should do them slowly and get them right, because inevitably, it's not clear that this particular controversy is going to be solved by the court. You know, technologically, things move on. But the precedential value really matters. The signal to companies that are already 5, 10 years on in their anti-competitive machinations, you know, are thinking about how Microsoft or Google or whomever got thumped. So I think the idea that you need to move quickly to be able to address this actual problem in this actual market is not really quite the way I think about it. And I think even the Microsoft decision, although the remedy was, you know, many viewed as sort of weak, I think it also created its own disincentives. I mean, if we think about the ecosystem of Windows after 2001 and the kinds of platform-dependent businesses that thrived on it, that then also became themselves platforms. So this is something I alluded to in my first remarks by saying, you know, when we privilege the creation of the platform to the exclusion of platform-dependent businesses, we actually are not only privileging the production of platforms because so many platforms themselves start out as independent, as dependent businesses. And I think there's an argument, and to this, I sort of owe this to my former student, Taylor Onings. This is a riff off an argument she made to me, that like maybe Microsoft was chilled in its dealings with Apple, Google in the 2000s that allowed it to sort of thrive, and especially Apple to do the iTunes thing, to drive the flywheel of what became the iPhone, now a platform-dependent business. So the way that these decisions play out in terms of incentives, I think are even more important than how they specifically react to this market in this moment.
All right, I'm going to ask we'll be a little short of the time we wanted to have, but we're running late, so any final comments from each of our speakers?
I'll just very briefly say, by way of part response to one of the things you said, so much monopolization, litigation, and analysis is about close reading and competitive close reading of the Microsoft record. This or that was argued, there was or wasn't support for this or that in the record. There's so much more, recognizing that great monopolization precedents are not thick and heavy on the ground, but there's so much more available, including much that is sort of better situated than Microsoft in some respects. So I would love to see monopolization analysis lean away a little bit from fighting over what was and wasn't proved, for example, on justification in Microsoft. But in practice, people focus deeply on it in just the way you suggest.
Yeah, I want to say one thing I've been puzzling about hearing some of the conversation, somehow the idea that some of my colleagues here have, that somehow this decision is so ill-defined that it can't be really used as a basis for figuring out anything, now. If you look at what Judge Mehta did in the Google decision, and I won't comment substantively on it, both in his motion to dismiss and in his opinion, it seems obvious to me that he wants to think about the Google case within the four corners of the Microsoft appellate opinion. Of course, that's his circuit, but it's binding precedent for him. But it's also influential, and it's the framework he brings to the case and frame that opinion in his thinking in his trial, and so it of course is telling him what to do.
Yeah, I agree, but I think that's a mixed blessing. So let me just give you one way in which it is. So it's pretty clear from the fabric of monopolization law outside of Microsoft that exclusion of at least one rival is a central element of a successful monopolization claim. Judge Mehta's opinion on multiple occasions, number one, says that defaults as such are fine and are not the illegal conduct that's being analyzed. And number two, says that both Bing and DuckDuckGo were never going to be in the default slot for the distribution channels under investigation. That comes awfully close to saying that neither Bing nor DuckDuckGo was actually impaired in its ability or incentive to win share from Microsoft by the illegal conduct, not the defaults, but the commitment to portfolio-wide default exclusivity. And I really fear for that on appeal, and I think it comes from Microsoft.
Well, I have to let someone else comment subsequently on that. I don't think that's quite right.
Me neither.
Can I throw in one last thought?
Go ahead, John.
If Microsoft would have been perfect, we would have nothing to talk about. It would be.
I will drink to that.
I think one of the reasons Microsoft is so significant is the lack of anything else. It really was the successor to Alcoa. There are elements of Aspen skiing in it. And as far as that burden shifting framework, any employment lawyers in the audience? 1973, the Supreme Court decided McDonnell Douglas. And McDonnell Douglas is a Title VII case, and it has a burden shifting framework that looks remarkably like the burden shifting framework that is used in the Microsoft case. And I have reason to believe it was an inspiration for that from talking to one of the chatty judges who decided Microsoft, who said that framework had been around for over 17 years at the time of Microsoft, and it seemed like a good way to think about and improve on the sort of vague standards that were out there. I think you also see it in Aspen skiing. It's not as formally set out, but it's how did this conduct affect consumers? How did this conduct affect rivals? How did this conduct affect the monopolists? It's there in the bones of Aspen skiing too. So when the DC Circuit says, based on a century of case law, he's trying to do a synthesis of a lot of different things that are out there. And I think if you look at McDonnell Douglas, you'll see that that was likely on his mind as well. We're gonna take our coffee break now. I want to thank our panelists for getting us off to such a good start.